In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
For today's an insightful session on resolution plan, we have our first speaker, Mr. Vineet Reddy Vakiti. He is a partner at Veera Legal LLP. He is an insolvency professional, commercial law practitioner, advocate with the prior experience of working with an insolvency professional entity, and he has founded a law firm which is engaged in insolvency bankruptcy matters. And he graduated from NLU Visakhapatnam, and he worked as legal officer with Canara Bank after securing All India rank of 17 in IBBPS. Following that, he pursued IICA's graduate insolvency program and registered as an insolvency professional with IBBI. He has worked extensively in the field of IBC, and he has supported senior insolvency professionals and IPs in CIRP and also liquidation in various structure portfolios, like diverse portfolios like infrastructure, pharma, manufacturing, poultry, data management services. Totally 8 ABC mandates, large accounts he has worked. Further, he was trained under NCLT members at NCLT Hyderabad, and he is founder partner at Veera Legal LLP, a boutique law firm which is doing very well at Hyderabad and across South and also Mumbai, all over India. They are NCLT practitioners and commercial law practitioners. They are also empaneled, and they have many cases by Aditya Birla and 3-4 large financial institutions. They are the legal counsel for them. They are the young GIP graduate law firm. And Vineet has worked as assistant legal manager at Canara Bank, and he is a research associate. He was a research associate at NCLT Hyderabad, and he worked with an IP at Hyderabad Easy Resolve. And he has many credentials in not only in IBC, in commercial law practice, and he is very good at strategy, litigation, and compliances in CIRP process. And he has worked on one of the subsidiaries of Lanco Group, Carvi Data, and also poultry, hotel, and toll. And he has been uh, very extensively working on the legal title tracings, due diligence with respect to land in the companies undergoing the CRP or liquidation under IBC. And he has handled complete CIRP of geospatial company under IBC, and he was the first person who has prepared the CAP personal insolvency resolution process reporting to NCLT, and he's assisted SBI, Shriram Finance, Yes Bank, Aditya Birla, and Bank of Baroda in large accounts. So if we go on, there are a lot of credentials to discuss about Vineet. He has worked in many resolution plans, and he is one of the strategists in IBC, I can say. So with this small brief introduction, now I request Vineet to kindly take over the session, please. Vineet, you are on mute. You are on mute.
Yeah. Thank you for the warm introduction, ma'am. Thank you very much. Thank you for the members who have logged in for the session today. And thank you, IPNet, and also Pavitra ma'am for the brief introduction. Thank you very much. So without wasting much time, I would like to jump into the presentation topic for today. So I'll be sharing my PDF first so that it will be easier for me to to make the session interactive with you.
You want to share PPT, Vineet?
Yes, ma'am. I mean, can you share it for me, ma'am? I'll send it to you across. Yeah, share it. So basically, today's topic is pertaining to the resolution plan and the approval process with the NCLT and the filing requirements, and also uh, the challenges which we face in from the NCLT, and how to handle the rejection from the NCLTs for the questions that have been asked these days across the NCLTs. I myself have the experience of handling the resolution plan approval processes, as many as five NCLTs here in down south, with NCLT Bangalore, NCLT Amravati, NCLT Hyderabad, NCLT Bombay, and NCLT Chennai. So, from my limited experience, I would like to break down the resolution plan process and how the NCLTs have been acting these days, and what are the precautions the RPs and the especially the RPs for the current matter to take care while any resolution plan is being submitted with the NCLT. So first and foremost, I like to give a brief introduction about the overview and the preparation process. Then I'll go to the preparation process of the resolution plan. So first and foremost, the overview of the CIP, which everyone here would be aware of, that once the company is admitted into the insolvency, the resolution plan must be submitted within the period of 180 days. However, these days the extensions have been granted by the various NCLTs, but again with a caveat. Only in the extraordinary circumstances these days the extensions are being granted, be it NCLT Bangalore or NCLT Hyderabad. So beyond, if someone wants to make the extension greater than 330 days, it's been quite a difficult ride these days with the NCLTs than compared with the earlier. I must be sure that all of you are also aware of these developments of late, wherein the extensions are not been granted very lightly, unless whether there is any NCLT stay or being any other practical difficulty which which have arisen during the CRP process, unless that the NCLTs are not inclined to pass any extension orders. In fact, they're directly going for the liquidation orders to be passed in the respective assignments, because they're taking the timelines very seriously these days, be it NCLT Bangalore or NCLT Hyderabad. The extensions are not being granted so lightly. So that being said, so the topmost priority now is to complete the process within 330 days, which is the time period that has been given to move in most of the cases, if not many. So basically, that is one point I want to highlight. And apart from that, one more challenge the RPs are facing these days when pertaining to the plan preparation process and the other process is the information that has to be received from the promoters. though the timeline starts ticking for all the the moment once the NCLT initiates the CRP process, the information that has to be received from the promoter is not being received rightfully. Recently, I filed an IA with NCLT Bangalore, wherein the necessary information that is required to issue the Form G, though for Form G was issued later on when the expression of interest were received from the prospective interest interested resolution applicants, the RP could not pass on the necessary information to them. Though we have filed 19.2 application, the time period that takes in a 19.2 application, which we are well aware of, the information has not been received yet. And subsequently, a contempt application was also filed against them. But however, that is also still pending. But for all of these reasons, that they cannot be used as a tool for extension with the NCLTs these days any which ways. So one thing what the challenge the RPs or the liquidators or anybody in the process of this who are facing is from the promoter's end where the information is not being received. But that being said, with the, whatever the information that is available on an as is where is going, the plan must continue and the plan must be received. That is why that is the reason where there could be certain gaps, wherein because of those gaps the proper assessment of the resolution plan could not be done. And I'll be dealing in this particular session what are the safeguards that we must take care in an event of sudden and sudden developments at the time of resolution plan, if something arises. Further, with respect to the everybody know here that NCLTs they should not go into any of the requirements except for the requirements that are mentioned in the section 30 subsection 2, the four cornerstones or the five cornerstones now, except for that the NCLT has no duty to interfere with the commercial wisdom of the CUC, which has been upheld time and again by the multiple NCLATs and multiple Supreme Court judgments, be it Maharashtra seamless on the less than liquidation value judgment, or the Shiva Industries judgment recently, wherein the settlement that was proposed was lesser than the liquidation value. The NCLAT had rejected it the same, but however they had to reverse it subsequent to the Supreme Court intervention and saying that they cannot intervene into the commercial wisdom of the COC, wherein they have when the COC approves to the fact that there is no the NCLT cannot intrude into the plan except for the things that are mentioned in the 30 subsection 2. Now let's see what are mentioned under 30 subsection 2. One is payment in priority to the CRP costs, which almost that RP would have full control of, wherein what are the process costs that have been involved till the plan approval stage. And second one is the minimum liquidation values to the OCs and the dissenting FCs. Now here comes the interesting part, that when you guarantee a minimum liquidation value to the operational creditors and the dissenting financial creditors, there are also conflicting judgments from the Supreme Court, especially when we are trying to make payments to the dissenting financial creditors, precisely because the OCs per se, the liquidation values, they don't have that problem. But the problem with the FCs and ascertaining at their liquidation values is there are two ways how the RPs across the country are calculating the liquidation values for the financial creditors. The first method is they ascertain the value to the FC, the liquidation value to the FC, based on the underlying security of the FC. That is like I'll explain it with an example. Let's say there are two financial creditors. One financial creditor has land and building as a underlying security with the financial creditor, and one more secured financial creditor has receivables as the security. Now, when the CRP is initiated, the value of the land and building will be obviously be calculated, and also for the receivables. The value that has been let us assume for discussion sake, the value of the land and building is 100 crores. The liquidation value for the land and building is 100 crores. So the liquidation value for one of the financial creditor is 100 crores. Now, the liquidation value for the receivables that are being hypothecated with one another financial creditor, that value is zero because of the limitation reason or whatever be the reason. Let us assume for the discussion sake it is zero. But however, the liquidation value of the underlying security being zero, they are being classified to the total amount of the debt that is submitted by the financial creditor towards the as a claim to the RP is being treated as a secured financial debt, and it is being divided by both the I mean, like, let's say the total value is 100 crores divided by 2, 50 crores to each of the financial creditors. This is one method which people are doing it. And in fact, the Supreme Court has upheld in one of the judgments, that the valuation of the assets individually and ascertaining it to the FCs is not legal when during the CRP process. That will only be relevant during the liquidation process. That being said, recently one more two-bench judgment referred it to a higher bench differing with the same matter. So now the point, though they did not struck down the earlier Supreme Court judgment, because the bench. So if you want to struck down the earlier judgment, you need to comprise a bench of higher in number. It should be a three-member bench, but that not being there, they have referred it to a higher bench with observations. However, the status quo now is, the value ascertaining and giving value to the financial creditors on the underlying security they hold currently is not implementable during the resolution plan process. But however, the matter is currently sub judice with the Supreme Court of a higher bench. Now, as and when the judgment comes out, the way the dissenting FC's liquidation value is to be calculated, which will take a major shift in the IBC process again, by giving each FC conducting valuation of the assets of the each FC separately and ascertaining their values and treating them as the financial secured financial creditor only to that extent, and giving the remaining portion of the debt as an unsecured financial creditor. And now when that comes in, that obviously will have an effect here in section 30 subsection 2, and how the plan amounts are being proposed to it. This judgment is the DBS Bank judgment, which appealed with the Supreme Court. I'll share the relevant material after the session to the members who have logged in. And that being said, the next one in the 30 subsection 2 is the management of the affairs after the plan approval. Now, these days, though this serves as a very generic one, wherein the management of affairs after the plan approval fundamentally vests with the successful resolution applicant who has submitted the resolution plan. But however, these days NCLTs are very particular when the plan implementation period is higher. Let's say greater than 2 years. They're very skeptical about approving such a plan which is higher in tenure, because what if there is any failure to implement at the middle of the plan, or after 2 years or 3 years, let's say. They have been very skeptical about allowing such plans, and they also want the COC and RP to implement adequate clauses within the resolution plan, wherein the adequate control and adequate means are being there for the monitoring committee to exercise their control. In fact, in one of the assignment for us, the bench suggested inducting a board member to the company even after the implementation of the even during the implementation, a board member from the financial creditors, or let the RP be him or her be the board member during the implementation process, to have a control on the management of the affairs after the plan approval. So now that is also one thing which is considered for only, but for the plans which have higher tenure of implementation. And the last and the important one is the compliance of law. Now, this is very broad. What is compliance of law? When a plan is submitted, it must be in adherence with all the necessary laws that are in existence as on date. Now, I'll explain with an example here as well. So, whenever any plan is submitted, nowadays, these days, the PF department claims are being given as they must be paid in entirety. Now, when the the payment towards the PF dues would derive during the resolution plan approval process would be derived from this particular clause in compliance of laws. So let me detail it out to you. So why we are paying the PF department the entire amount? On contrary, you don't pay it for the any other employee benefit acts itself. I'm not talking about any other act, let's say for that matter, the income tax or the GST or whatever. Let's say the gratuity part. The gratuity part, whenever a gratuity claim comes, it also sits on, if the gratuity fund is already there with the company, the fund will be distributed. Or if not, that again falls under section 53. Unlike PF dues, wherein the PF dues sit outside the section 53, the gratuity does not hold the same footing. So why does that happen? Because in the PF act there is a provision very clearly which states that the PF department is going to have first and foremost charge even before any other government entity or any other entity for that matter, be it under SARFACI or whatsoever. Uh, that's why they have a higher footing than any other thing. And I'll explain it to you. If in fact, if an asset which is not bought into the CRP or the company is not bought into CRP, if the property is auctioned through SARFACI, completely under SARFACI, even then they must, out of the proceeds that are received out of the auction, there are judgments from the Supreme Court which says that by the provisions of the PF, even before the property, the bank exercising the mortgage over the property, they have to adequate, the PF would have even prior charge than them. And that's why the instances wherein the banks even before, after auctioning, have set aside the amounts that are being to be paid to the PF. So the payment to the PF department does not come from the IBC or the NCLT judgments whatsoever. The payment priority to the PF in fact is derived from the provisions of the PF Act itself. Now, why does it happen? Because the recovery process under the PF, they mentioned it very clearly that this is going to be the first and foremost charge. And even the PF have a non-obstant clause which says the same thing. Now, which is not the same with the gratuity or any other thing, wherein the arrears or dues will be recovered as an arrears of land revenue. Now, arrears of land revenue, though they be treated as the arrears of the land revenue, they come under the 53 at a later point of time on footing with the other statutory dues. So that is the reason why. And many people also miss out the fact that there is one more law on par with the PF, which also requires to be paid in totality, which many people will use, which is ESI. Because the provisions of the ESI Act are on par with the PF Act, which many of the RPs would usually miss in, wherein the ESI is not being paid in entirety compared with the PF. And sooner or later, even I'm anticipating that the ESI department also would be filing necessary applications with the NCLT, NCLAT, and would be getting an order wherein, because the provisions of the PF Act and the provisions of the ESI Act are exactly similar, and the provisions are in fact similar to that extent where the in fact you would be finding them as copy paste of each other. So if that is applicable to the PF, the same should be applicable to the ESI is my logic. Now when that becomes a judge made law, I think everybody would be aware of that thing as well. So now under this, so that's why in the compliance of law, there are many aspects of law which we deal with, for a plan to be in compliant nature. I'll give you one more example as well, wherein, what about the treatment of the third party contracts under the resolution plan? So I have the opportunity to, work on Lanco Huskote case while I'm working with Easy Resolve IPE, wherein, the company had a concessionaire agreement with the NHAI, wherein they construct the road and then they start collecting the tolls. And after the completion of the toll, for the every 5 years, a major maintenance activity must be taken care of. So the road was completed, Lanco Hoskote Road was completed in the year 2013. And after 2013, I mean, the first major maintenance should be done in 2018, and then at 2023, and then at 2028. Subsequent and after 2028 major maintenance being taken care of, the toll will be handed over to the NHIA. The concessionaire would come to an end. But however, in 2018, the company had defaulted. They did not undertake any major maintenance. And later on in 2020, 2021, the company got admitted into insolvency. And when it got admitted into insolvency, a resolution plan was received by the Kalyan Toll Infrastructure Group, wherein while they were laying down the plan, they've mentioned it very clearly in the resolution plan that they're going to undertake the major maintenance in the year 2023, a minor maintenance immediately after taking over, and one more major maintenance in the year 2028 before handing it over to the NHA. But however, later on, the NHA came in and protested before the NCLT, saying that this is nothing but unilaterally they're amending the concessionaire agreement, wherein the concessionaire agreement mandates three major maintenances. The resolution plan mandates only two major maintenance and one minor maintenance, which which is nothing but amending the contract that is entered between the company and the NHA unilaterally, by the resolution applicant, who is not a party also even before the approval of the plan. That being said, however, the COC remarked that it is the commercial wisdom of the COC, stating that they have approved the resolution plan, and if nobody would come forward to make the major maintenance three times, because there is not enough timeline for them to collect the tolls. Because even if they would have lived, even if the resolution applicant had undertaken to make three major maintenances in a span of 7 to 8 years, they could not receive the amount that they would be incurring for undertaking three major maintenances. So that put us in a catch 22 situation. However, the legality wise, the NCLT was inclined that it amounts to the unilateral modification of contracts, and that can't be done. Unilateral amendment of contracts is not permissible under law, and it's not in compliance of law. But however, luckily in that particular case, due to the efforts of the RP and as well as the RA and the bankers and COC as well, they were able to convince the NHAI for only two major maintenances, and they have agreed to the same. Or else, had if that not be the scenario, there would be another plan which we all been reading on the unilateral amendment of contracts by the resolution plan, and the failure to adhere to the compliance of law, which is mandated under section 30 subsection 2. Now, the compliance of law is such a vast thing. I mean, there are so many judgments under the same ambit, uh, also which also brings us to the point, wherein, the NCLT and NCLAT these days, while approving the resolution plan, they're also inclined to, see the what is the net worth of the particular RA, and also, how are they going to implement it, how are they going to demonstrate the feasibility and viability, and what did they plan really address the cause of default, and what are the proportions of the settlements that have been proposed to the creditors. I mean, everything fall under regulation 38 more or less. Under these and section 30 subsection 2 must be read along with regulation 38 to see whether the plan is in compliant with all the necessary requirements. But however, here, while they're dealing with this particular aspect, the NCLTs are delving much into the capability of the RAs, the net worth of the RAs, the latest net worths they have been asking. In fact, in NCLT Bangalore, you need to submit the latest audited financials, if at all the company, the company, if it is bidded by a company, and also, if it is bidded by the company, if it is bidded by a person or a consortium, whatever, for whatever reasons, all the net worth must be established very strictly, which is a non-negotiable. The bench is not inclined to pass any order if that is not being established. And also, when it comes to the implementation schedule as well, if there is no upfront payment proper, and all the payments have been proposed only after 2 years or 3 years, then even then, even under those circumstances also, the NCLT is pushing for adequate safeguards. How are the COC or the monitoring committee, how are they going to look after the plan after the plan has been approved by the NCLT? And One more thing is section 29A, which everyone is aware of. If someone is not eligible under section 29A, definitely there is no way they're going to submit the plan. And if they're not submitting the plan, again, the planning process would not even arise. So now, when the voting is been taken care of, one more key important factor that would come into play is, whether any differential treatment is possible among creditors. If there are 4 to 5 creditors, uh, whether one creditor be given a different of same class. Let us for a moment assume that all of them are of operational creditors, or all of them are financial creditors, whether one creditor be given 25% of the total amount, total admitted amount, and one creditor be given 30% of the total admitted amount. Now, this particular point, is deliberated by the Supreme Court in SR Steel, and they've upheld the point that the differential treatment among creditors is applicable. But however, the some NCLTs delve into it, and because of the fact that a differential treatment is given, there is a possibility always that that class of creditors or that creditor in person might challenge that with the NCLT. But however, the law is pretty settled there. The differential treatment among the creditors is permissible under the resolution plan. And and also one more thing the NCLTs would look into is the performance bank guarantee. So performance bank guarantee is also one thing. It must be for the entire period of the resolution plan, what they're going to give for I mean, because that acts as a fallback mechanism for the stakeholders that have been involved. So that is one particular thing also which is very pertinent asked by any NCLT. And also to prove the feasibility and viability of the plans, this is such a vast topic to prove the feasibility and viability of the plan. And so this particular point is being, how they are going to establish is only been dealt by the RAs in the plan, but they're not been discussed at much length. If you look, five out of 10 plans, the feasibility and the viabilities of the plan are not recorded properly. How are they going to revive the company? So this becomes important in the fact that, if at all there are any other shortcomings that are being reported, let's say, the plan, let's say the plan is lesser than the liquidation value, then the feasibility and the viability of the plan must be in such a way that why the COC in fact had agreed to that particular decision, that even if it is lesser than the liquidation value, they've agreed to it, and what is the viability behind the plan, and what is the motive of the COC in agreeing to that particular this thing. So that also can become with track record, expertise, and the financial capability of the RAs, and the business continuity, the employment preservation, all of these qualitative factors that might come into play. But however, that must be taken very important care if there are any other shortcomings in the resolution plan which would not otherwise arise. So now when it comes to the approval process, the NCLTs are seeking for the affidavits, multiple affidavits. Each NCLT has a set of affidavits. Let's say, one affidavit is required under the law as well, that who is going to peruse the avoidance transactions. So the whether the successful resolution applicant is going to take forward, or whether the financial creditors or the operational creditors, any creditor, who would substitute into the avoidance applications that are being filed, an affidavit to that effect. An affidavit also is mandated in various NCLTs with respect to the that they have not failed in implementing any other resolution plan earlier. And there are also the on affidavit and on oath they're asking the financials to be disclosed as well. Whereas in NCLT Mumbai, the process is entirely different, wherein you need to submit a complaints memo, which the format that is prescribed by the NCLT itself, which is available, wherein that it must be given in that particular format only, along with the plan form H, which is already being there. And now there's also one more interesting question that arises during our practice, that is, the law is fairly clear that once a resolution plan is approved by the COC, they cannot send it to the COC for the revision of the resolution plan. And if at all, if any revision of the resolution plan is happening, or a modification of the resolution plan is happening, they must withdraw this and submit the fresh plan. But however, interestingly, in one of our cases, if that being said, whether the form H that is being submitted along with the plan, whether that can be modified. However, for us, the NCLT Mumbai accepted in submitting the revised form H not once but twice, taking a stand that is different from the other established practices across the NCLTs, wherein they allowed the RP to amend the form H and submit the form H, but however, they wouldn't allow the modification of the resolution plan as such. Uh, and then what NCLT cannot do while interfering with the plans is, they definitely cannot interfere with the commercial wisdom of the COC, which is time and again upheld by the many judicial forums across the country. And they cannot modify also the resolution plan, which is already approved. They cannot modify the resolution plan, and also they cannot examine the valuation when no stakeholder objects to the same. Now, recently we have seen a case in Chennai wherein they have appointed a new valuer altogether and to see the valuation. But however, the valuation was the same as what as the valuation that is being given by the RP. But had if any different valuation has been errored, this particular question would have been deliberated much in detail, wherein the valuation, they cannot step into the shoes of the valuation and impose their own commercial judgment to that particular fact and say that the valuation is conducted is not in order, because the valuation reports, as per the new amended regulations, the same will be presented to the COC as well. Once the COC goes through them and admits to the valuation methodologies that are being adopted, now NCLT cannot reinvent the wheel again and say that no, the valuation which was being reported to the COC and the the method of valuation that has been deployed is not in order, and then that particular thing cannot be done. And that has also been deliberated in MK Rajgopalan versus Pereswamy Palani case in the year 2022, that they cannot, when there's no objection to the valuation raised by any stakeholder, it is not open for the NCLT to enter into the issue of the valuation of the assets and make it a ground for the rejection of the resolution plan. But then what would be the grounds for the rejection? Otherwise, only rejection would be the non-compliance of section 30 subsection 2, wherein the RPS must be very careful when it comes to the compliances of the other laws, because the compliances of other laws, there will be many laws in at play and many interplays of IBC with the other things, and the plan must be in compliant with all of them to become a complaint resolution plan. And any lack of the what the provision mandates, be it under say regulation 38, only under that circumstances they can reject the plan and nothing else. uh, and so the document checklist for the for NCLT filing purposes would be the Form H and the COC meeting minutes and the voting records, whether it's physical or e-voting, or information memorandum, RFRP, valuation matrix, and the valuation reports, and section 29A affidavit, and also the undertaking by the resolution applicant under regulation 39, and the net worth certificate, and the performance bank guarantee, and the source of funds documentation, the due diligence reports, and the letter of intent and the acceptance of the same, and the monitoring committee mechanism details, and the implementation schedule. So these are the documents more or less all the NCLTs mandate for. Whereas in some NCLTs they mandate even more. Instead of the undertakings, they ask for affidavits in some NCLTs, and in some NCLTs they have their own format of a checklist that has to be submitted along with the formats, yeah, like in NCLT Mumbai. So in all these cases, these particular different mechanisms, so small changes, but more or less all the necessary documents, whatever they might mandate to, are covered under the list that I've been reading out just now. All of them would be, would be required for filing a resolution plan with the NCLTs. Now, that being said, if you have any other questions, pertaining to the filing process and also the rejection process, I'm free to answer them. No, the PRA cannot make. There is a question from Sandeep Kotari, that can the PRA make the plan, condition on the basis of the reliefs and the concessions? Or thanks for asking that question. I missed that point. So the reliefs and concessions cannot be a ground for for the RA to implement the plan or not. Whether or not the reliefs and concessions are were given by the NCLT or not, that must be that must be implemented by them, and he cannot take that ground, because one such important thing for a plan to the prerequisites of the plan is that the plan must be unconditional. It cannot be contingent upon any condition to be fulfilled, but the plan must be unconditionally given by the PRA. Only then it will be a legally compliant plan. So that is not permissible for the question asked.
Yeah. So we'll have the Q&A session now. I request members to kindly post their queries, or they can unmute and ask the questions to the speaker. Any questions from the participants?
Hello,
Hello.
Yes.
I am Vimal Kumar.
Yes.
You have told that in the class of creditors,
Yes.
differentiation is permissible.
Yes,
Like
sir.
two financial creditors are there. One claims 2 crore, one claims 10 crore.
Yes, sir.
In proportionate financial, this COC can
Mm.
admit or to one person 8 crore they can give, or in one person 1 crore they can give. Is it possible in, to financial creditors?
Yes, sir. It is possible as per me because
And what should be the criteria? How? Because
the
two
criteria
banks are there,
in
two banks are there.
sorry.
How will they agree?
Yeah, if see, sir, I mean, the if the person who is being given a lesser payment, it would definitely, would not accept the conditions that are been imposed by the resolution plan by the RA. But I'll give you an example, sir. Like in a small CUC, the problem would be a deadlock, that must be accepted by both. But in a larger COC, sir, when it comes to, a very bigger COC, there are instances wherein, the differential payment has been given to the parties, and they've challenged the same with the NCLTs. But that
Also,
part,
it is litigation matter, no?
it's a litigation matter that has been upheld though. But like, because in the same SR steel judgment which was given, they have what they have taken in that particular the stand in that particular case is that up to 5 crores, who have submitted claim, they gave one treatment, like 20%, let's say 20% or 30% of the total admitted claim, and greater than 5 crore, 10 crore, they gave even lesser proportionate, or greater proportionate. So based on, they have differentiated certain classes, and then they have done, and which was upheld by them. Now that particular dynamics would be differing from one COC to the other COC, wherein the RA would be proposing payments, let's say one creditor is having 80% of the stake, and the major share is allotted to them, and if the other one dissents, the safeguarding provisions are already being there, that they cannot be granted less than the liquidation value. Now that being said, just for the proportionate purposes, now the NCLT cannot go and say that to the COC that you give the same amount of same amount to the other party also, wherein I have already given him the liquidation value that is entitled for that particular creditor. So, I mean, though that can be a litigation matter, in my opinion, it cannot be a ground for the rejection from the NCLT. Yeah, I mean, there's a question from Sandeep Kotari, sir, that among the government use, only PF claims are to be settled mandately, and the other claims. Yes, sir. But in my opinion, even the ESI claims also must be mandatorily be settled if you go by the provisions of the ESI Act as well, along with the PF Act, because the both the provisions of the PF Act and the ESI Act are very similar, wherein the provisions of that particular act creates first charge on all the assets of the company, no matter what, and that would be the first and foremost charge, not any subservient charge, like the dues will be treated as an arrears of the land revenue, or the dues will be treated as any other financial creditor, any other on par with any other statutory dues. Only for ESI and the PF, we must be mandatorily if you look at the provisions. But however, that's been followed only for the PF department by uh, majority of them. Whether the differential treatment can be given in case of the home buyers. Interesting question, because interesting question by the Sham or Raji. When it comes to the differential treatment in the home buyers, it would be quite a tricky thing. Not in whether it's permissible or not. I'll go there again. But the home buyers as a class are usually been represented by one particular. One particular representative, who authorized representative on behalf of the entire home buyers. So in order to draw such particular parallels, that would be very difficult. But however, legally, purely legally speaking, it can be done, but however, that depends on if it has any differential mechanism, such as, one has a villa or in the project, or one has a apartment in that project. Only then that would be that would be possible, or else, that could not be possible, to differentiate among the home buyers. It would be very difficult for them. Or, the differentiation, even though it could be possible, it must have one parlance on the admitted claim amounts, or, the nature of the home that they're acquiring, any logic behind that. Or else, even the differentiation is allowed, it cannot be, arbitrary, saying that, I'm going to give to this person, I'm not going to give to this person. Even if something comes in, like, I can say that I'll give you the liquidation value, I can say that I can give you this particular amount to get the plan approved, but it cannot be arbitrarily saying that I'll give it 9 home buyers and I will not give to the one more home buyer. It cannot be that way. The arbitrary test would be there, even if the differentiation is been carried out. There must be some logic behind that.
Excuse me, I am Purnachandra Rao, insolvency professional.
Yes, sir.
After commencement of CRP, ED has attached the assets of the CD.
Yes, sir.
Sir, what is to be done by RP?
Sir, when it comes to ED and PML attachment, sir, so basically, under the PML Act itself, there's a provision of Section 88, wherein when the trial is pending, that particular property would be, restored back to the financial creditor itself. Uh, that being said, there are multiple judgments, from the. So I can ask one more question: whether the attachment is done after CRP or pre-CRP?
After CRP commencement.
So, and after CRP, when NCLT Hyderabad, there is a judgment which says that after CRP, they cannot, the attachments cannot be made, and also that are also upheld by the PML appellate tribunal, not pertaining to the CRP process, but in another case of Axis Bank. After CRP, the attachment has no logic. But however, the NCLTs these days are not venturing into that, saying that whatever attachment is there, you go there, you go to the respective PMLA, PMLA courts to, revoke the attachment. Though they're saying it illegal, they're not passing any orders to make the
Yes, yes.
attachment release. So
Yes, yes.
that being said, however, they're giving the liberty to the RPs, they give this caveat to the RAs, saying that there is a property attachment. You take that case with the PMLA separately. However, being that on an as is where is basis, you continue with the resolution plan process, which is
Okay.
in the current way ahead that has been taken, because the NCLTs are of the opinion that they cannot revoke the attachment that has been already made, even if
Yes,
it is
yes,
in
yes.
the CRP
The
process.
process has to go on.
The process has to go on as an as is where is basis. So
Okay.
Even
that's
after that circular from the IBBI, the process has been simplified now.
It
Now
will
RP
take
has
time,
to
sir.
simply file an undertaking with the PMLA court, I think.
But it takes time, sir.
Yes, the undertaking
That of-
has to be filed. Yes, there is an amendment to the
Yes,
regulation.
the circular is there. It takes time because after cognizance of the case only can file. Just like that, immediately you cannot file it.
No,
It
it
takes
will
time.
run separately, sir. It will run separately actually. For the reason being, there is no need to go for the trial in this matter. See, you have filed the application and undertaking, and they
Yes,
have to file the reply only as per that circular only.
Yes,
yes, sir.
yes.
Yes, sir. Even in fact, in my case also, we have visited Enforcement Directorate hearing last month. So even
Hmm.
they have the circular. They are aware of this
Yes,
latest
yes, yes.
from IBBI. So we can make the RP can
And if
take.
you'll see that declaration is also at the site of the ED also
Yes, right. You
Okay. 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 Thank
on
you.
the same lines as it is issued by the IBBI.
yes,
Okay. Thank you. Thank you.
it is almost the same process what Mr. Vinith is trying to explain. It is the same process, only that undertaking is the additional point. It is again the same application.
Okay. Okay.
Yes, sir. They have clearly mentioned about that section 8 also of PM.
Okay. Okay.
Yes.
Let's hope for that कि ये जल्दी हो जाए
हाँ,
ये सब इश्यू
yeah.
बाकी ईडी
Yes.
But in one case of Kingfisher, they have released some assets. I think that company was under liquidation.
Yeah. I mean, they'll release it, but however, even in the 8-8 proceedings also, sir, I mean, which is not before the IBC, but usually there are two stages in any PMLA matter. One is, the criminal aspect of the PMLA, and one is the civil aspect, that is the attachment of the properties by the enforcement directorate. Now, when typically whenever any attachment confirmation is being done, first there will be a provisional attachment, and then there will be the confirmation of the attachment within 180 days. Now, once the final confirmation of the attachment is being done, then the matter, usually there will be 2 points to it, wherein this can be appealed with an appellate tribunal under the PML Act, which the majority of them are doing, and afterwards the matter will be reverted to the special courts that are designated in each state. Now, when the matter is with the special courts, the trial would be continued, and during the trial, they are going to ascertain the fact that whether they have been guilty of the crime and the charge sheet that has been filed by the PMLA department, from the ED department. Now, while the trial is undergoing, the 8.8 is basically an enabling provision for all the financial institutions and any claimant for that matter. They can file an application before that special court saying that, that under 8.8, I'm eligible for the restoration of the property in my favor during the pendency of trial. But however, even in that particular proceedings also, when we are filing it, like the department and the special courts demands an undertaking in 8.8 proceedings as well before the PMLA court, which says that, in an event tomorrow, this particular property is been obtained from the proceeds of crime under the PMLA Act, then you need to return the amount which must be deposited with the ED at later point of time. They give that undertaking, and only after giving that particular undertaking, they'll restore the property back. So that undertaking is already there in existence before the special courts. Now the same has been, being
No,
adopted.
RP is giving that undertaking.
So RP
Basically,
will not give
new
it. Usually
undertaking is
the undertaking will be given
yes.
by the financial creditors, usually who have a legitimate interest on.
But in
No, no.
IBBA circular, RPA is giving, sir.
Yeah, in IBBS circular RP is giving, but yeah, but the end users are, not the RP, no, sir. I mean,
In
RP
this
is
case,
not
it will take more than 1 year time, it seems. It takes
uh,
time, na? Because CRP timing is 180, 270 days or maximum 330 days now. But PMLA court proceedings will take more time.
True, sir, true. But however, for 8.8, they're not taking much time, sir. I've handled 2 8.8s in Hyderabad and one 8.8 in Bangalore. Surprisingly, the ED department itself is filing an objection on the first date of hearing itself in Hyderabad, saying that they have no objection to the restoration, subject to the terms and conditions and the undertaking given by the financial creditors who is having
But
an.
hearing itself taking time, sir. That is the problem.
I mean,
That is the problem.
that is the practical aspects attached,
Yes, sir.
sir.
Yes,
But
yes.
that the undertaking process already been the reason why I'm saying this is the
Mhm.
undertaking is otherwise, even without IBC also there is an undertaking process which has
Okay.
to be done by the FCs. Now the same thing has been inculcated here in the NCLT processes as well to make it hassle free. It
Okay.
should be easier.
So, any more questions? Any more questions? So, if there are no questions, I would like to thank Vineet for on behalf of IPNet and from all the participants and the organizing team. We extend our sincere thanks to you, Vineet, for taking the time to speak at the webinar. And your session was extremely insightful and well received, especially the your practical experience with the NCLT. You have shared what are the issues which may come up before the bench, and also about the technical questions from the participants. and you have the practical perspectives you have shared added immense value to all the participants. And we are grateful for your time, effort, and willingness to share your expertise with us. It was a privilege to have you as our speaker. We truly appreciate your contribution and thank you. We will share a memento. We will get it delivered to your office. And on behalf of IPNet, thank you very much, Vinit.
Thank you, ma'am. Thank you, everyone, for listening to me. And kindly excuse me if there are any mistakes or whatever, and I'm ready to rectify them as well. Thank you, everyone. Thank you, everyone, for giving me this opportunity.
Thank you. So we will now have a very brief session from me on regarding the practical issues which during the process the RP has to ensure, take care so that the application is filed properly with the NCLT and with less mistakes or with less errors the application can be moved, and with less queries we may get the plan approval if everything is filed properly. So as an insolvency professional, what are the best practices we need to ensure, especially in the context of resolution plan? I would like to share only very few important points with all of you. One is, once the Section 7, 9 or 10 application gets admitted, the corporate debtor is admitted into CIRP, a moratorium is imposed, and the commencement of CIRP process kicks in. And with the process, the interim resolution professional, who is the insolvency professional, he issues the public announcement inviting the claims. So once the claims are invited, within 14 days of invitation, the creditors will submit the claims, and once the claims are submitted, the after verification of the claims, the IRP constitutes the committee of creditors, and the committee of creditors will provide the direction to the RP for entire CIRP process. So as there are three stages in the CIRP process. One is the commencement of CIRP, then constitution of COC, then we have the expression of interest process, and then preparation and due diligence and the commercial wisdom of COC, the approval of resolution plan by the COC, and then taking up with the NCLT. So the NCLT will either approve the resolution plan or reject and pass the liquidation order. The entire process takes 180 days, and it is also extended from case to case basis upon the committee of creditors approval seeking extension from adjudicating authority. So once the committee of creditors is constituted, the RP issues the IRP or the RP issues the expression of interest and prepares the VDR and information memorandum, and also the request for resolution plan and evaluation matrix is prepared in consultation and approval of the committee of creditors. And to the expression of interest, in the market, the prospective resolution applicants, after going through the VDR information memorandum prepared by the RP, the prospective resolution applicant submit the expression of interest. So after the expression of interest and within the timelines, the RP also takes care the process of valuation during the process, and also the RP has to form an opinion of any avoidance transactions during the look back period, and then after the expression of interest, the provisional list and final list of prospective resolution applicants is prepared by the RP, and the final list of the resolution applicants from the final list of the final list of eligible prospective resolution applicants, the applicants will submit the resolution plan, and after the resolution plan is submitted, the RP will do a due diligence of the section 29A and also verifies whether the plan is a compliance plan, and then puts up before the COC for voting. So there are certain important checklists which the RP has to ensure. There is, after the CRP regulations, there is a CARP timeline process. So ensure that once the process gets admitted, you follow that timeline strictly, because the compliance of CARP timelines and the IBC and the CRP regulations is mandatory. As we have seen in the Bhushan Steel case, the non-compliance has been taken a serious view by the Supreme Court. And during the process also, as a best practice, you open the form H and keep filling the details, so that how many times the expression of interest is given, and who are the valuers, what is the valuation. So all this without missing, we have to ensure that how many COC meetings are held. So form H is a very good compendium kind of a checklist which helps RP in the final resolution plan stage preparation. And one important regulation I wanted to highlight is, in case if the total assets in a CARP process is more than 100 crores, it is mandatory for RP to prepare a marketing plan and get it approved through the committee of creditors, and ensure that the marketing plan is executed for the resolution of the company. And even the valuation is also very critical in the CARP process, as the valuation is the benchmark for the committee of creditors. And even in the form H, the NCLT also, while reviewing the contents of the resolution plan, they also ask for these important compliances. And when evaluation, RP has to support the committee of creditors in the due diligence process of the section 29A eligibility, and also evaluation of the resolution plans. And the main, as Vineet was covering, the major compliance under section 32, the most common grounds for rejection is whether the operational creditors are paid minimum liquidation value, and whether the plan has the proper implementation and management of CD post plan approval, and whether the resolution plan is providing the reasons for debt and default, and whether the default is addressed in the resolution plan, and what is the implementation mechanism available, and whether the voting percentage requirement, that is 66% committee of creditors have approved the resolution plan, whether the plan is feasible and viable, whether the committee of creditors have considered the feasibility and viability of the resolution plan at the COC meeting. So ensure that at the meeting where the resolution plan is discussed, ensure that the committee of creditors is also reviewing the feasibility and viability of the resolution plan and record it properly. And even the regulation 38 compliances checklist is there in the form H. So please ensure whether the resolution plan terms are within the compliance of this regulation 38 also. And as an RP, whether the material misstatements or any fraud statements have been provided in the resolution plan. So these are the major few important points which I wanted to present while preparing the resolution plan. When the preparation of the resolution plan, the prospective resolution applicants will take the support from RP and his team, RP and his or her team, and also in consultation with RP, they will be preparing the plan. So ensure that the plan is within the contours of the law. And this one is pre-filing of the application for resolution plan, and the other one is post-filing the resolution plan. So pre-filing the resolution plan, it is better that you have the proper CRP timelines checklist, form H, all your committee of COC meetings summary, and ensure that all the important process related things are captured in your checklist, like valuation, who are the valuers, what is the valuation, if 2 or 3 valuers are appointed, what is the average of the 2 nearest valuations, Then when was the VDR issued, when the information IM was issued to the PRAs, all the dates, COC meeting minutes, everything you have to have a summary so that it is all the compliance, filing of the forms with IBBI, all these details you have to ensure, because in the Form H you are giving the declaration that you have complied with all the IBC and its regulations made thereunder. And one more important point is, while passing the resolution at the COC meeting where the resolution plan is put up for voting before the COC, ensure that 3 mandatory resolutions are passed. One is sale as a going concern under regulation, under CRP regulation. If the plan is not approved, whether COC is approving for resolution, the CD as a going concern sale, then liquidation cost. Then there are 3 important resolutions which have to be passed along with the resolution plan approval. So the other one is, let me just check. One is liquidation cost, sale as a going concern, and liquidator fees. So these 3 has to be taken up at the COC meeting. Even if COC rejects, these 3 resolutions has to be put up mandatorily for the voting of the committee of creditors. So pre-filing, ensure that you are filing all the important process related documents with the along with the application, and especially the affidavits which you are collecting from the prospective resolution applicants. And in case if you are taking any due diligence certificates also, those certificates are not mandatory, but sometimes the RPs are filing along with the application, and the resolution plan and the annexures thereto, and the COC meeting minutes, the performance bank guarantee. These are all important documents. Form H, all this has to be filed with the NCLT while the adjudication of resolution plan IA. And post filing, while hearing, if in case NCLT has any queries regarding the contours of the plan, during the hearing, they may ask for any affidavits or any declarations from RP or COC. In our case, during this hearing of the NCLT, the application with NCLT for approval of the plan, the bench has asked for the resolution from the committee of creditors that they wanted the nomination from the financial creditors on the board of the corporate debtor or RP. So we convened the COC meeting immediately and took the resolutions from them, and we filed the affidavit. And sometimes even during the hearings, in case if the PBG expires. So like this, NCLT from case to case basis, they may ask the RP or COC to file some affidavits or any undertakings. So when we see the latest Bush and Steel case, the Supreme Court has held that the compliance of the code and its regulations are important for the in the process. Non-compliance of the code and the regulations have taken a serious. Hence, hello. So the NCLT and the Supreme Court upholding the objects of IBC, the speed, value maximization, and the objects of the IBC, wherein the resolution plan, approval of resolution plan is the process of IBC. So with this few remarks, I now request members to kindly post their queries, if any.
Good evening, madam. I have a query.
Yes, sir.
So, in my case, the resolution plans that we received were rejected by the COC members, and
Okay.
post which the one of the PRAs is writing to us that he is willing to discuss with COC further on this and uh, take this forward if anything is possible. Now already we are about to touch 300 days of CIRP, and on 31 December the CIRP period is expiring. Is there any recourse available, any kind of possibility that COC has in such scenario?
Vineet, are you available to take the query or you want me to answer? Um, Okay. So I'll take your query, sir.
Yeah.
So see, in your case, the 180 days period has expired, and now the PRAs whose plan is rejected by COC, they want to come for negotiations.
Yes.
So once COC has rejected the plan, maybe 180 days extension have you filed? You have not.
Yes, we've already taken extensions and 300 days are about to expire now.
Okay. Sir, in this case, it is better that the PRA move an application with NCLT and seek their directions for COC to reconsider their plan.
Okay, and what if COC is willing to do it? Can we as RPs file the petition for
Sir,
relief?
COC with their voting, you take the voting from COC and take their consensus, and then it can be filed on behalf of COC. Yeah.
Okay, even though 300 days have expired, there is still a scope for us to do this.
Yeah, but there should be a plan, concrete plan, which in the view of COC, that the plan will be a commercial wisdom, that the plan is there and it is going to be approved.
Okay,
Yeah.
okay, thank you. And just one remark on this, ma'am. The three resolutions that you were saying, right? The liquidation as a going concern.
Yes. Yes.
So those regulations have been omitted. So that resolution alone is not required anymore.
No, sir. See, the sale as a going concern and also the liquidator fees, those
Yeah,
has,
yeah. The liquidator fees and expenses are to be done, but
yes,
the provisions relating to sale as a going concern during liquidation,
yes.
those have been omitted.
Okay,
Yes,
in the
it
new
will.
bill.
It will not be there now. It will not be there now. Only two resolutions.
Yeah, yeah. New bill, it is being amended.
Yes.
New bill, yes.
No, no, no. The going concern thing is already deleted.
Okay.
Not new bill. Not new bill, ma'am.
That alone is not required. The other two resolutions are needed.
Okay.
Yes, yes.
Okay, sorry. Yeah. Okay. Any more questions, sir? So otherwise, any more questions, sir, from the participants?
Just one practical aspect I want to understand. So, in case of MSME, when the suspended directors themselves are submitting a resolution plan, assuming their plan gets approved and later on the avoidance applications that have been filed get admitted against them, then what is the position? I mean, how does it practically work in such scenario?
So you mean to say that the plan is getting approved and also there are cases of avoidance transactions which they are getting an order.
Yeah, that happens subsequently because on the date of submission of their plans and filing of plans with NCLT, only applications have been filed for avoidance, no decision has been made. So subsequently, let's say their plan gets approved and the avoidance applications which have been filed by the RP, they're admitted later on. The liability is put on the directors. In such case, like what happens to these resolution plans that get approved?
Uh, Sir, let me just share my view, and I also I'll invite Vineet also to answer this query. See, being MSME, they are eligible to submit the resolution plan, and also on the date of submission of the plan, there is an ineligibility which is applicable. Hello, sir. Am I audible?
Yes, yes, you are.
See, while submitting the resolution plan, on the date of submission of the plan, the ineligibility should be applicable.
Yeah, so on the date of plan, if only avoidance applications are filed but not yet decided against them, they are still eligible.
They are
So, so
right.
as on that date, they've submitted the plans, and let's say it has not happened, but if it happens and COC approves their plan and we file it with NCLT also, and let's say NCLT also approves it, later on when the avoidance applications are decided against them, then how does practically, how does it work?
I mean,
Prac-
this is already being settled, sir, in one of the case, if I may answer to the query, wherein, the RP, while conducting the due diligence should only be considered with as on date point of view. Like we cannot, take into consideration what might or what may happen at a future point of time. As on that particular date, the order should be there and the order should be final in nature. I'll give you one more example also, sir, in fact wherein the 29A eligibility comes in with respect to the disqualification to act as a director. If they are disqualified to act as a director, they cannot submit the plan. That being said, the NCLT, in fact, the Supreme Court in one of the judgment gave an order saying that the order must come explicitly from the ROC that he's disqualified as a director. So even though like they have not filed any financials for the 4 years or 5 years of you all, even that they have fulfilled all the criteria to be disqualified as a director, unless the order of confirmation of such comes from any of the entity which is supposed to do so, RP cannot disqualify them under 25A. So that basically is that there must be a finality in and the finality must come from the appropriate authorities which are supposed to give that orders, and only then they'll be disqualified. Till then they would be eligible to do the same.
Right. Yes, sir. Because see, the RP is concerned only till the approval of the resolution plan. He becomes the functus officio. So, as Vineet has pointed out, so our role is checking whether he is eligible as on the date of submission of the plan, the ineligibility, and practically the creditors who get into the who will be the based on the resolution plan approval, who are the beneficiaries of the avoidance transactions, they will take a view on the further course of action on that. So, hope we clarified, sir. Sandeep, sir.
Uh, See, that point is fine, ma'am. That as on that date only we have to see and we have to file the, resolution plan eligibility has to be, checked on that date. But if later on, because these applications later on can still get admitted, right? The avoidance applications, then what happens to the resolution plan that the director submitted and it got approved? Does it impact the plan or that can continue to be implemented?
Sir, practically, if you see the promoters who are the MSME promoters, they give the plan. They obviously they'll have the favorable terms in the resolution plan regarding the avoidance transactions.
Yeah, but the COC specifically got them removed. That there should not be any, whatever avoidance applications are there, the financial creditors would stand to benefit. So they asked them to remove the point that these applications will not be pursued further.
So if they are the beneficiaries, ultimately they may pursue or they may not, they may withdraw also these applications post implementation. And if there are any concrete orders against the promoters, even that implementation is again the vested with the creditors. So Vinith, if you want to add anything to this, sir's query is post implementation, during the implementation of the plan or post implementation, if there are any orders on the avoidance transactions, whether what happens to this MSME promoter eligibility, or he has submitted the plan.
So in my opinion, basically, if something of that sort happens, I mean, if we are, it would be different for each stakeholder because there is no, standard answer for the question because that is the difficulty and the law is pretty much silent on that. If I were the RP, I'll file an application and bring the same on record with the NCLT. Let that be done in protection of the interest from the, from the monitoring committee chairman point of view or the RP point of view. If I'm the stakeholder, if he's paying money, I'll just keep quiet and wait for the plan to be implemented so that it can get done. So ideal thing is to report it to them and let them take a call through an IA. So if at all they want to they want to take any action, they might take it. But in my opinion, that would only be in 29A objections are only to be seen at the submission of resolution plan itself because the section itself says so. So if there are any subsequent developments after that, should not be affecting the implementation is what my opinion. Uh, but that is not adjudicated yet by any of the NCLTs, if I'm not wrong.
Right.
Okay,
Yes.
thank you.
Thank you. So, so we have completed both the speaker sessions. So we will have the IPNet East. So I just want to make an announcement on behalf of IPNet East. They will be having the next webinar on next Saturday. And now we will conclude the webinar with a vote of thanks. So good evening, everyone. So we are honored to extend the vote of thanks for today's webinar. Today's event has been a good learning experience for all of us regarding the resolution plan practical issues. So first and foremost, our heartfelt thanks to our distinguished guest speaker, Sri Vineet Reddy, for sharing his profound insights on a very critical and practical concept under IBC. We are grateful to you for your time, wisdom, and experience. We would like to express gratitude to our IPNet President, Mr. Ashish Makija, for his commitment and leadership, who has made the IPNet an exemplary initiative and platform of great significance for insolvency professionals. Thank you for being a guide to all of us. A special note of appreciation to IPNet South for successful, smooth conduct of this webinar. And thank you for the invaluable contributions of transition and technical team for their seamless coordination. And our gratitude to all the participants who have joined us today. Your enthusiasm, active engagement, and thought-provoking questions and contributions have truly made this event a special. Thanks to all once again. Thank you, everyone. See you all next IPNet webinar on Saturday. Thank you. And advance Happy New Year to everyone.